How long do I have to file an injury claim in Kansas or Missouri? Hi, I'm Kevin McManus. I'm an injury attorney who practices in Kansas and Missouri, here to answer that question for you. So the legal concept that you really need to understand to answer this question is something called the statute of limitations. A statute of limitations is a law that basically sets forth the deadline for which you've got to file your claim in court. And if you fail to file your claim in court within that deadline and the statute expires, or as we say, runs out, then your claim is extinguished. What that means is it's gone. It's totally legally obsolete. You can't file a case. If you do, it'll be dismissed. Your right to recovery under the law is extinguished and gone as well. And no insurance company is going to pay you on your claim. And so the penalty for failing to follow the statute of limitations and getting your case on file on time is very harsh. And that's why it's extremely important for you to understand this concept. Now, to put this in perspective, I think it's worth understanding generically what the statute of limitations is for an injury claim in Kansas and Missouri. Of course, with your case, you're going to want to, I think, seek the advice of an attorney, even a free consultation, to make sure you understand what that deadline is and how it applies to your case. Because as we'll see in a moment, the statute of limitations changes based on the type of claim you have and on the law that applies. So for instance, in Kansas, the statute of limitations for a personal injury action or a wrongful death action is 2 years. And what that means is you have to get your case on file with a court in Kansas within 2 years of that injury or that wrongful death, or your case is forever barred. Again, very harsh penalties. If you don't, your case is going to get dismissed. In Missouri, that statute of limitations is a bit longer. But here's the thing. You don't want to wait anywhere near the statute of limitations in order to file your case. At our firm, we pursue these cases very quickly, very promptly, and don't get anywhere near the statute of limitations for one basic reason. If your case is on file and there's a change that you need to make, maybe you need to file an amended pleading, maybe you need to add a new party, maybe even a new cause of action or a new count that you need to set out in your pleading or petition, because facts through discovery changed, you may be barred from doing so if the statute of limitations has already run on your case. So your case may be filed and you may have a valid claim that you think is good against somebody, but then the facts change and you find out that somebody else is at fault. That statute of limitations could still bar you from asserting a new claim against somebody else. So that for that reason, again, really want to emphasize that you should get your case on file as soon as you can, and of course seek a free consultation, at least with an attorney like our firm, before you do anything, because you want to make sure you understand what the statute of limitations is and how it might apply to your case. Again, thanks for this question. Feel free to reach out with any other questions, and appreciate the time today.